Friends, today we discuss the transfer jurisdiction of the Supreme Court. We know that various types of jurisdictions are there for Supreme Court. This transfer jurisdiction is one of that jurisdictions which can be say as original jurisdiction, a part of original jurisdiction. Part of original jurisdiction. Now, there are three types of jurisdictions. Parts are there in transfer, particular transfer jurisdiction. What are those? The power of the Supreme Court to transfer any case can be given by which is given by Section 25 of CPC. So, Section 25 CPC bestows some power on the Supreme Court to transfer case, and what are the modalities, procedure, grounds, and everything we will discuss later. Now, there is another transfer jurisdiction power of the Supreme Court that is regarding criminal matters. Criminal matters, CRPC, Section 406 of CRPC gives another power, that means power regarding criminal matters. Come to third type of jurisdiction, that is Article 139A of Constitution of India, transfers. That means this is another power derived from Article 139A. So what is the difference between these types, these three types of powers, and when 139A can be exercised, and all other details we will discuss one by one in this video. Now come to 25 CPC. So according to Section 25 CPC, civil matters can be transferred from one state to another state, one high court to another high court, or other. Come to now, you see, this power of transfer also is one of the part of administration of justice, which can be done by higher courts. So this is also important judicial functions of higher courts. You can see Section 24 and 25 of CPC. Section 24 enables the high courts and district courts, whereas Section 25 Supreme Court. So come to Section 24. What is the heading of the Section 24? General power of transfer and withdrawal. That is the heading of Section 24. So according to that Section 24, what is the power? So any high court or the district court. It is the power of the any high court or district court. This Section 24 contains 5 clauses. Section 24 contains 5 clauses. You come to section, we will see what is Section 24. We will see the verbatim, because 24 and 25 is connected. So we have to see 24 also. Of course, we will discuss in detail about 25 because it is a Supreme Court jurisdiction. But in the same time, as a collateral section, correlated section, we have to see what is Section 24 also. So as I told now, the Section 24 contains 5 subclauses. Come to one by one. So here, who can apply? According to one, who can apply the power? Who can apply for transfer, or how it can be initiated? The transfer power of the High Court or District Court. How it is initiated? On the application of any of the parties, that is one. On the application of any of the parties, that is one. Any parties means that side or this side. So simply the question who covers. And next, what is the next? Application made. Notice to the parties. So notice has to be sent to the parties, other side. And third, after hearing such of them, them means both sides. All sides, you can say all sides. So application, notice, hearing. Hearing as desired to be heard. Such of them as desired to be heard. So all parties. So this is one. The second option is who can apply of its own motion. Of its own motion. Own motion means court itself. So court itself can transfer. So here without such notice. If it is sumoto, no notice. But the High Court or the District at any stage. The original section language is like this, without such notice. Maybe normally without hearing other parties, even on the application of any of the parties and other situations also, this cannot be normal situations proceeded. Okay. So who can apply? Two options. One of the parties, any of the parties, not one of the parties. Any of the parties means plaintiff, defendant, or any implead something or something. Or normally in a suit, only two parties, either that side or this side. So next, what can do? Transfer any suit. Only suit? No. Appeal, suit, appeal, or other proceeding. Other proceeding means all court proceedings. What is the condition? Pending before it. What is the condition? That should be pending before it. Either district court or high court. For trial or disposal to any court subordinate to it. So pending means not before high court or district court. Lower or disposal to any court subordinate to it and competent to try or dispose of the same. So transfer to who? Where? Transfer to any court subordinate to it and competent to try or dispose of the same. So here the condition is before it means what? Before it means what? Suppose somebody files an application, then it is pending before it. So who can transfer? High Court or District Court. To which court it can transfer? It can transfer any court subordinate to it. So the condition is subordinate. Subordinate and competent. Subordinate and competent. Just because subordinate we can't transfer. It should be competent to try it. Suppose any district, any senior civil judge court or family court or like that, any sessions court, so it should be competent that dispose of the same. So that is one condition. Next, not only transfer, withdraw any suit appeal or other proceeding pending in any court subordinate to it. So here, transfer from one court to another court. Withdrawal. Withdraw. When the case is pending subordinate court to high court or district court, then it can withdraw the suit or appeal or other proceeding. That is another power. The third power is try or dispose of the same. That means what? The high court or district court can itself try, or it can itself can dispose of the same. What is the same? Same means which is pending before subordinate court. Suppose one suit is pending senior civil judge court. So any district court can withdraw the suit from senior civil judge and try itself. In the same way, high court. Transfer the same for trial or disposal to any court subordinate to it, competent to try, dispose of the same. So here, what about this transfer the same for trial or disposal to any court? After withdrawing from the, here this is different. This is A. Situation A is different. Situation B is different. So after withdrawing, try itself. After withdrawing, transfer the same. After withdrawing, retransfer the same for trial to the court from which it was withdrawn. So transfer power, withdrawal power, trial power, transfer power, and retransfer power. So it can do anything. Next, this is enough for our class purpose. Now come to section 25. Section 25. 24 deals with the High Court and District Court. 25 deals with the Supreme Court. On the application of, here we will do one thing. We will highlight this. Make this. Type. So, on the application of a party, here a party means any party. A party means any party. So, any party can make application. That is one. Next. Suppose it is on the instance of any party. What is the rule? Notice should be given to the parties. The parties means all parties. So, application is over, notice is over. Next, what remains? Hearing. Hearing of the same as desired to be heard. As desired to be heard. So, hearing procedure is up to the court. Next. Then after completion of these conditions, that is application, notice, hearing, then what can do Supreme Court? At any stage, so there is no bar of stage. There is no bar of stage. That means what? Nobody can argue that is in advanced stage. That is in advanced stage. So you cannot hear. We can't say that because the statute permits the court at any stage. So what is the condition? Satisfied. So satisfaction of the court is the condition. Satisfaction of what? An order under this section is expedient for the ends of justice. The only clause which is to be satisfied, which is to be required to be satisfied by the Supreme Court is that expedient for the ends of justice. What is the meaning of expedient? You see. So we understand better way, Convenient and practical, although possibly improper or immoral. A means of attaining an end, especially one that is convenient but possibly improper or immoral. So expedient means, when you see synonyms, convenient. What is that? Convenient. So advantageous. There are two situations. So come to the meaning of the word expedient. Expedient means convenient or advantageous. Expedient for the ends of justice. For what? Ends of justice. So when this condition is satisfied by the Supreme Court, upon compliance of these three conditions of application, notice, hearing, then Supreme Court can direct. What can it do? It can direct any suit, appeal or other proceedings. So according to this phrase, any suit, any appeal or any other proceedings means every proceeding before the Supreme Court. So every proceeding before the court be transferred from a high court or other civil court in one state to a high court or other civil court in another state. So from a high court or other civil court in one state. So here it is from which a case has to be transferred. From which? Either it may be high court or any other civil court, but it should locate in one state. The same can be transferred to either in a high court, either to high court or other civil court, but where it is another state. So state to state. State to state. It can transfer. Okay, so that is section 25, class 1. Now come to class 2. class 2 regarding procedure. So now we see one aspect. What is the total essence of the section 25? Okay, first we come there. So now what is the essence of section 25 clause 1? Who can apply? Who can apply? So any party. Next, what is the procedure? That means stages. After application, the next stage is notice. Notice to the parties. Notice to the parties. Means all parties. Next, hearing. What is that? Application, notice, hearing. Hearing. To whom it hear? Such of them. That means all the parties. Such of them. Hearing of such of them. How? Hearing is how to hear? As desired. As desired. Next. At and which stage it can be transferred? Any stage. What is that? Any stage. Okay. What is the ground to be transferred? Satisfaction of the Supreme Court. Satisfaction of the court. That means Supreme Court. Okay, satisfaction regarding what? Expedient. It is expedient. Expedient for the what? For the ends of justice. Expedient for the ends of justice. If Supreme Court satisfied that it is expedient for the ends of justice at any stage after hearing as desired, which followed which is preceded by notice to the all parties and application by one of the parties, Supreme Court can transfer. Transfer from which place to which place? That means one state. That means court situated in one state. What is that court? It may be High Court or any civil court, not criminal court, because it is a CPC. So, court is situated, that is a High Court or civil court is situated in one state, can be transferred to another state. Another state to which court? Same, High Court or civil court. So, this is the essence of 25 class 1. Okay, come to class 2. What is class 2 says? This class 2 says that every petition or application under this section made by a motion which shall be supported by an affidavit. So we know that petition plus affidavit. Normally, what will be there in affidavit? Supporting contents of petition. We know that. Every petition shall be followed by affidavit which contains the necessity and the facts and circumstances which lead to file this petition. Okay, now come to 3. So, what is the next procedure? Direction is over, transfer is over, transfer to another court. Then what is the procedure? Where to begin? The transferee court. Transferee court means where this case has been transferred to. This transferee court either retry it or proceed from the stage at which it was transferred to it. So, 2 options. Retrial. Retry means from the beginning. So, one is retrial. Retrial. Second is from the stage which it was transferred. At what stage? The matter has come to transferee court. From that stage also it can hear. So that is this section, 25 class 3. Okay, suppose Supreme Court not transferred, dismissed the application of transfer petition. So can it impose cost? Yes. When it can impose cost or compensation, that is subclass class 4. When Supreme Court can impose compensation is that Supreme Court, if it is opinion that the application was frivolous or vexatious, application is frivolous or vexatious. Frivolous or vexatious, then compensation can be awarded to any person who has opposed the application. Such sum, how much? Not exceeding 2,000 rupees. So, compensation 2,000. As it considers appropriate in the circumstances of the case, not exceeding. That means even below 2,000 also it can be imposed. Then, under which law the transferee court has to heard the matter and decide the matter. So the law applicable. What is the law applicable in the case? Though it is transferred to transferee court, that is original law. That means the law applicable which the court, which is the suit appeal or was originally instituted, ought to have applied to such suit appeal. Suppose any amendments are there from state to state, then original court statute is applicable. So that is 5. That is clause 5 of section 25. So now what we have completed, it is verbatim and introduction of the transfer power of Supreme Court under section 25 CPC has been completed. Now come to the scope or grounds. The scope or grounds of under which this power of transfer can be exercised. You see, section 25, before amendment, that is before 1976, section 25 empowers the government, not court. This is strange issue. Section 25 empowers the government before 1976 amendment for what? To transfer the case after report from the judge. Report from the judge concerned of the High Court. So that has been removed. In fact, it is in restricted power. In fact, it is restricted power, but after the amendment, the power of section 25 is far wide. What is this? Far wide. It has far wide power. Okay. Section 25, the power language is similar to section 406 CRPC. Okay. So now we come to scope. So one word, one phrase we have. What is that? Expedient. Expedient to the ends of justice. That is the reason, that is the condition to be satisfied by the Supreme Court. So then what is expedient to the ends of justice? We don't know. The language, the statute says that only if it is expedient to the ends of justice, then Supreme Court can transfer the suit appeal or other proceeding. So then what is expedient to the ends of justice? There is no definition, but it should be judged upon by the totality of facts and circumstances. It will have to be judged. Will have to be judged. That means what is expedient to the ends of justice has to be decided by court by basing on each facts and circumstances of each case. Okay. We can't give any definition for the meaning of expedient to the ends of justice. It is only can be decided on the hearing of the case by the court on each petition. Now come to some of the grounds, some of the normal grounds on which Supreme Court can can exercise this power. That means these are practice. We can say that practice of the Supreme Court on grounds. On which grounds it is exercising its power. That is convenience and inconvenience. Convenience and inconvenience of whom? That is the point. Convenience, inconvenience of the parties, witness, trial place. So, defendant or maybe plaintiff convenience can be taken, or inconvenience of them can be taken. Convenience and inconvenience of the witness can be taken into consideration basing on the facts and circumstances of the case. So, this convenience and inconvenience of a particular place of trial having regard to nature of evidence on the points involved in the suit. So, place of trial. So, this also can be taken into a consideration. Particular place of trial, convenience and inconvenience. The other things are that, suppose if any party is having reasonable apprehension in the mind of the that he might not get justice in the court in which the suit is pending. So, reasonable apprehension. Reasonable apprehension. Reasonable apprehension from by whom? By a litigant. That means one of the parties. What is that reasonable apprehension? The reasonable apprehension of he or she might not get justice in the court in which the suit is pending. Suppose from the court, the litigant has a reasonable apprehension that it may not get justice. In such condition also, it is also one of the ground. So, these are the some of the grounds. Of course, there are other grounds also is there. These are only illustrative but not exhaustive. These are only illustrative. That means, for example, so all this is about transfer power of the Supreme Court under section 25 CPC. We will discuss the power of the Supreme Court regarding